Hi, I'm James Frampton. I'm a junior barrister at Keating Chambers. This is part of a series of webinars which members of Keating Chambers are providing on the Building Safety Act, covering all sorts of different topics. And today the topic I'm going to be talking to you about is the leaseholder protections in Part 5 of the Building Safety Act. One of the key parts of the Building Safety Act, and particularly in Part 5, is the new protections for leaseholders from service charge costs. This is set out in section 122, which says that Schedule 8A provides that certain service charge amounts relating to relevant defects in a relevant building are not payable, and B makes provision for the recovery of those amounts from persons who are landlords under leases of the building. Now, broadly, the idea is to provide protections so that leaseholders do not have to foot the bill for measures to address relevant defects under their service charges. And if they are faced with such service charges, then leaseholders can make applications before the first tier tribunal for a determination of liability to pay and the reasonableness of those service charges under Section 27A of the Landlord and Tenant Act 1985. So those applications always existed, but there's effectively a new limb, which is now regularly relied on to say, well, these service charges are excluded by the Building Safety Act. And these measures should be seen as sitting alongside the other elements of Part 5 of the Building Safety Act, such as remediation contribution orders, which give landlords alternative cost recovery measures to pursue. So the Parliament's taken away from landlords. On one hand, they can't use the service charge, but given them other routes to use, particularly against the original developers. Now, before we move on to consider the detail of the protections in Schedule 8, in terms of scope, there are two key points. Firstly, the protections only apply to charges for remediation of relevant defects in relevant buildings. And that's in keeping with the other elements of Part 5. That's what Part 5 of the Building Safety Act is concerned with. So just to pick up those two elements, relevant defects is defined in Section 120 as a defect as regards the building that arises as a result of anything done or used, or not done, not used, in connection with the relevant works that causes a building safety risk. There's obviously a few phrases in there to unpack. Relevant works means works relating to the construction or conversion of the building, if done in the relevant period, works and all works undertaken or commissioned by or on behalf of a relevant landlord or management company, again, if completed in the relevant period, and works taken after the end of the relevant period to remedy a relevant defect. The second wording to unpack was a building safety risk, because obviously a relevant defect is a defect which causes a building safety risk. And that's defined in Section 125 as a risk to the safety of people in or about the building arising from A, the spread of fire, and B, the collapse of the building or any part of it. The other element then, after relevant defects in the protections, limitation of protections, is a relevant building. This is defined in Section 117. It must be a self-contained building with 2 or more dwellings, 11 metres or 5 stories high, and not in one of the excluded categories in Section 117.3. So one point to bear in mind is that these protections, none of them will apply or cover charges for routine maintenance. They are still can be service charged under the terms, subject to the terms of the lease. The protections apply to relevant measures for relevant defects. So you can always have that debate, is this defect or is this part of the routine maintenance? For example, do you have to maintain the automatic opening vents because they would always require that maintenance? So that's the first key limitation on Schedule 8, relevant defects in relevant buildings. The other key limitation is temporal. Section 122 says service charges are not payable. And the question has already arisen as to what service charges are covered by the Building Safety Act, which came into force in 28th of June 2022. And the Court of Appeal has already been asked to look at this question in Adriatic Land 5 Limited versus long leaseholders at Hippersley Point earlier this year. And the question for the Court of Appeal was whether the Building Safety Act prevented the recovery of service charges from tenants of a building in respect of certain costs which the freeholder had incurred before the relevant provisions of the Building Safety Act came into force. One argument in front of the Court of Appeal was that the Building Safety Act had no retrospective application. That was by the appellant, and the respondent's argument that it had complete retrospective application. And the Court of Appeal decided, confined between the two, that it had no application, the Building Safety Act protections, to costs incurred before 28th of June 2022. So once the landlord had incurred the costs, it had a contractual entitlement to payment of service charge, even if not yet demanded. And on that point, as to whether when they're incurred, the Court of Appeal said, well, it's the standard Landlord and Tenant Act analysis that the landlord incurs the costs for when it's invoiced or pays for the works. So the question is, if the landlord is invoiced or paid for works before 28th of June 2022, then the Building Safety Act protections cannot apply to those service charges. So it's only looking at costs incurred by the landlord on or after 28th of June 2022. And now an application for petition to the appeal to the Supreme Court is ongoing. And so that there may be a further change in the law in that respect. So with those two limitations in mind, we can then turn to Schedule 8. And as you work your way through Schedule 8, there are two key features. One is the different protections it provides, and the other are the three key presumptions which can be found within the provisions. So just to work way through the different parts of Schedule 8 in order. The first protection is paragraph 2, which says that no service charge is payable under a lease in respect to the relevant measure relating to a relevant defect if a relevant landlord is A, responsible for the relevant defect, or B, is associated with a person responsible for a relevant defect. Now, there's a couple of key points here. Firstly, paragraph 2, unlike the other protections, applies to all leases. It is not just qualifying leases, it applies to leases. And that's been confirmed in Lehner versus Lant Street Management Co. by the Upper Tribunal and by the Court of Appeal in Adriatic Land. Now, it may seem fair that if the landlord is responsible for a relevant defect or associated with someone who has, of which look at the relevant provisions of Building Safety Act, the test of association, that they can't service charge for the costs of rectifying that defect. But importantly, there is a presumption which can apply to this provision. Paragraph 14.2 allows for the Secretary of State to make regulations that presume a landlord is responsible for relevant defects unless the landlord provides a tenant under the lease with a certificate. And this is called the landlord certificate. Now, while paragraph 14 is headed presumptions under qualifying lease, the actual provision is not so limited, and of course the headings are no part of the statutory interpretation. Now, the Secretary of State has made those regulations under paragraph 14.2 in the Building Safety, open brackets, Leaseholder Protections, close brackets, England Regulations 2022. And Regulation 6 states that the current landlord must provide a certificate, and the regulations set out what's contained in those certificates, and there is a form for the certificate available on the government website. In these 5 situations: A, when the current landlord makes a demand to a leaseholder for the payment of a remediation service charge. B, within 4 weeks of receipt of notification for the leaseholder that the leasehold interest is to be sold. C, within 4 weeks of becoming aware of a relevant defect not covered by a previous certificate, or D, within 4 weeks of being requested to do so by the leaseholder. And E, finally, within 4 weeks of becoming aware of a new leaseholder deed of certificate. So in those situations, a landlord must provide a certificate meeting the required form, and if they fail to do so, they will be presumed to be responsible for the relevant defect and then won't be able to service charge for them. In Lena and Lant Street Management, the upper tribunal took the view, importantly, that given these regulations came into force on the 20th of July 2022, the presumption, the deeming provision, did not apply to service charges demanded before that date, although they did express they weren't addressed on a possible argument by which it could be argued that it did so. Now, the other point to bear in mind on certificates, which can be an onerous obligation, is they are really just a foot in the door for a landlord. The fact that a landlord gives a certificate won't mean that they definitely weren't responsible for the defect. It just means they are able to challenge the presumptions, and they're not caught by the presumptions. Whereas even if a certificate is given, the leaseholder can still challenge what's stated in the certificate and say, no, not as a matter of presumption, but as a matter of fact, the tribunal can find you are responsible for the relevant defect. So that's paragraph 2. And as I say, that protection applies to all leases. When we move through the other protections, the key point is these only apply to qualifying leases. So paragraph 3, no service charge is payable under a qualifying lease in respect to a relevant measure relating to relevant defects if the landlord at the qualifying time met the contribution condition. So key points to unpack here. The qualifying time is 14th of February 2022. The second point, the contribution condition is that the landlord's group net worth at that time was N times 2 million, where N is the number of relevant buildings. So the exercise you need to do is to identify A, what's the landlord's group, and that is the relevant landlord and persons associated with them. So you need to look at the association test in section 121. Then how many buildings are owned by the landlord and its associates. And finally, what is the net worth of the landlord and its associates. Now, because it's only at the qualifying time, you don't need to keep doing this every time you issue a new certificate. You only need to do this once for what was the group, what was the net worth, what were the number of buildings in February 2022. Again, there is a presumption that applies here, because by paragraph 13, and this is the second presumption, the presumption is that a lease which meets the basic criteria of being a long lease of a single dwelling, tenant liable to pay a service charge, and granted before the 14th of February 2022, will be presumed to be a qualifying lease unless a landlord has taken all reasonable steps to obtain a qualifying lease certificate from a tenant and that certificate has not been provided. Now, so that is a presumption in terms of qualifying lease, which is important to bear in mind. So as I say, paragraph 2, all leases. Paragraphs 3 onwards, qualifying lease, but there is a presumption that most leases, which in those basic, all leases meeting those basic criteria will be qualifying unless the landlord has taken that step. There's also a third presumption which applies specifically to paragraph 3, the contribution condition, and that's paragraph 14(1) of Schedule 8, that a landlord at the qualifying time will be presumed to have met the contribution condition unless a certificate is provided complying with the prescribed requirements that the landlord did not meet that condition. And I think the way to interpret this will be unless and until that certificate is given, the landlord will be presumed to have met the condition. And even if you give it later, I think that was not going to give you relief. It would only give you relief moving forward. You'd effectively presume to have met the condition until the point at which you give a certificate. Now, while paragraphs 14(1) and 14(2) refer to separate certificates, which give rise to the different presumptions. In practice, it would normally be the same landlord certificate, which deals with both, deals with we're not responsible for these defects, so we can get rid of that presumption, and we don't meet the contribution conditions, we can get rid of that presumption, of course, if that's correct. The third protection then is paragraph 4, which is to do with the value of the lease. So no service charge is payable for a relevant measure for a relevant defect if the qualifying lease at the qualifying time, so 14th of February 2022, is worth less than £325,000 in London, £175,000 elsewhere. Of course, again, that's qualifying leases, but qualifying leases being subject to that possible presumption. So if your lease is below those values, you can't be service charged for relevant measures. So again, you can see Parliament thinking, well, if you have a more valuable lease, you can have to pay for service charge. Paragraphs 5 and 6, then, those are limits to the amount of a service charge, again, under a qualifying lease to permitted maximums, which are set out in those paragraphs. Paragraph 7 is similarly a financial limit, and this time it's an annual limit for service charges for qualifying leases. Paragraph 8 states that no service charge is payable under a qualifying lease for cladding remediation. So you can see that's a particular response to Grenfell. A lot of the work's being carried out is cladding remediation, and Parliament is very keen to ensure that those costs in particular are not passed on to leaseholders. And in terms of what is cladding remediation, that is defined as something which forms the outer wall of an external wall system and is unsafe. So potential debates as to, okay, well, is it remediating the outer wall or is it remediating another element of it? The final protection is that paragraph 9 says that no service charge under the qualifying lease for legal or other professional services relating to liability incurred as a result of a relevant defect. So you can't service charge for legal assistance with a court case, so on, against someone else. So it's just making clear that those costs can't be pushed on to leaseholders. So overall, there's a broad range of protections which are set out in Schedule 8. And if it's perhaps the most important point for landlords and tenants considering whether they can rely on these protections from what we already have thus far. Firstly, the current decision as to the dividing line is that they will apply to costs incurred by the landlord after 28th of June 2022 only, being incurred by the landlord in terms of invoiced for the works or they paid for the works. Anything before that, you cannot rely on these protections as the law currently stands. Secondly, paragraph 2, responsibility for the relevant defect, that applies to all leases. Where in contrast, the other protections apply only to qualifying leases. But there, an important point is there is the presumption that certain leases will be qualifying leases unless the landlord has taken the required steps. And that's the third and final point, is the landlord needs to think very carefully about the presumptions which do arise under Schedule 8, which means that unless the landlord has taken steps to serve proper and timious certificates, they could find that even though they may have an argument as to why they shouldn't be caught by these rules and should be able to service charge, they will not be able to do so. But of course, regardless of those presumptions and so on, you only end up getting into Schedule 8 if they are costs for relevant measures, for a relevant defect in a relevant building. So none of these protections would apply to what is still routine maintenance. That debate will always remain and wouldn't be covered by a presumption.